Law of contracts. Definition and forms of contracts. The law of contract is concerned with the legal enforceability of promises. In that context, a contract may be described as an agreement that the courts will enforce. This notion of enforceability is central to contract law. If you breach the contract, the other party has several legal remedies. Firstly, he can sue you for damages for breach of contract. Also, he can ask the court to order you to perform the contract. If you breach the contract, the other party has several legal remedies. Example, Mr. Fernando has agreed to sell his land to you for an agreed price. You later hear that Mr. Fernando is planning to sell the same land to another person. You can ask the court to order Mr. Fernando to sell the land to you, as agreed, and also for an order injunction to prevent Mr. Fernando from selling the land to the other party. At the outset, it is important to note that contract law in Sri Lanka is part of the law of obligations and is governed by Roman Dutch law. However, there appears to be no fundamental difference, except in one or two main areas, such as the requirement of consideration, between the Roman Dutch law and English law concerning contracts. Secondly, it should be noted that contract law is largely based on judicial decisions, judge-made law, rather than in a single statute or code, although in some areas affecting contract law, for example sale of goods, and more recently consumer protection legislation, plays a major role.